This is Barry Zalma on insurance. Today it's time to talk about the concept of fortuity. Because the purpose of insurance is to protect insureds against unknown risks, fortuity is an inherent requirement of all insurance policies that take on the risk of loss accepted by the policy. The Fortuity Doctrine precludes coverage for both a known loss and a loss in progress. A known loss is a loss that the insured knew had occurred before making the insurance contract. The doctrine has its roots in the prevention of fraud because insurance policies are designed to insure against fortuities. Accidents. Fraud occurs when an insurance policy is misused to insure a certainty. The California Supreme Court considered the complex questions of insurance policy coverage interpretation that arose in connection with a federal court-ordered cleanup of the state's Stringfellow acid pits waste site. The Supreme Court initially addressed the continuous trigger of coverage, as that principle was explained in Montrose Chemical versus Admiral Insurance Company, and the all-sums rule adopted in Aerojet General versus Transport Indemnity. The California Supreme Court brought to an end the dispute that started in the 1960s when the Stringfellow acid pits began to leak in a case called State of California versus Underwriters at Lloyd's, a 2006 decision. Oddly, the fortuity principle never appears in insurance contracts. The principle is rooted in common law and in the statutes of at least 6 states. The fortuity principle has the effect of an exclusion. That is, an all-risk policy might provide coverage for all risks minus named exclusions, but never provides coverage for non-fortuitous events, even though non-fortuitous events are not named exclusions in the policy. For this reason, the fortuity principle is sometimes called the unnamed exclusion. An accident exists when any aspect in the causal series of events leading to the injury or damage was unintended by the insured and a matter of fortuity. Because the purpose of insurance is to protect insureds against unknown risks, fortuity is an inherent requirement of all risk insurance policies. The Fortuity Doctrine precludes coverage for both a known loss or a loss in progress. A known loss is a loss the insured knew had occurred before making the insurance contract. A loss in progress occurs when the insured is or should be aware of an ongoing progressive loss at the time the policy is purchased. Insurance coverage is precluded where the insured is or should be aware of an ongoing progressive or known loss at the time the policy is purchased. The doctrine has its roots in the prevention of fraud because insurance policies are always designed to insure against fortuities. The California Court of Appeal attempted to silence the problem in a case called Home versus Landmark in 1988, which held that only the insurer on the risk at the time of the first manifestation of loss is responsible for the entire loss. Trial courts have been loath to follow the loss in progress rule and tend to keep all insurers in the lawsuit for fear of letting the wrong one out and depriving the insured of a remedy. As will be seen, Prudential LMI Commercial versus Superior Court, a 1990 decision should have silenced all disputes on the subject in California. It is yet to be seen whether other states will follow California's lead. The loss in progress rule is designed to protect against contingent or unknown risks of harm that happen before the occurrence of the damage-causing events should determine what policy responds to a loss. The argument has no effect, however, on other conditions of the policy. The SNAP decision only stands for the proposition that the contingent event insured against has occurred. The insurer is required to indemnify its insured, even if damages continue to occur after expiration of the policy. In fact, that authority is authority for the loss in progress rule. The conditions of the policy regarding notice, proof of loss, and suit cannot be ignored. On the contrary, the law is clear that the conditions relating to notice and proof of loss are conditions precedent to suit. For example, according to the Supreme Court of Kentucky, inherent in the plain meaning of the term accident is the doctrine of fortuity. Indeed, the fortuity principle is certain to the notion of what constitutes insurance. The court defined fortuity as consisting of two central aspects, intent and control. This was in Liberty Mutual Fire versus K&K Contracting, a 2013 decision of the Kentucky's courts. At the very least, fortuity excludes intentional or fraudulent losses and normal wear and tear. Fortuity, a claim for faulty workmanship, for example, in and of itself is not an occurrence under a commercial general liability policy, because a failure of workmanship does not involve the fortuity required to constitute an accident. It has been held that although the insured has the burden of proving a loss is fortuitous, the burden of demonstrating fortuity is not a particularly onerous one. The determination of whether a loss is fortuitous has three components. A loss which was certain to occur cannot be considered fortuitous and may not serve as a basis for recovery under an all-risk policy. In deciding whether a loss was fortuitous, a court should examine the party's perception of risk at the time the policy was issued. Ordinarily, a loss which could not reasonably be foreseen by the parties at the time the policy was issued is fortuitous. In determining whether an event constitutes an accident so as to afford the insured CGL policy coverage, courts must analyze this issue according to the doctrine of fortuity. 1. Whether the insured intended the event to occur. 2. Whether the event was a chance event beyond the control of the insured. And 3. If the insured did not intend the event or result to occur, and if the event or result that occurred was a chance event beyond the control of the insured, then CGL coverage covering accidents will apply to the benefit of the insured. The California Court of Appeal in Snap v. State Farm, a 1962 decision, expressed its concern with the cancellation of a policy after a continuing loss had occurred and was still occurring. It concluded that the insurer could not absolve itself of the loss until the problem had been rectified or it had paid the full amount of indemnity owed, that is, its policy limit. It did not, as some might argue, conclude that the policy continued after its expiration, only that the loss had changed from a contingent event to an actual event. The occurrence of the damage-causing events determines what policy responds to the law. Courts often draw on the restatement of contracts to deal with the need for a fortuitous event for insurance to respond. The restatement defined a fortuitous event as one that is dependent upon chance, taking into account the knowledge of the parties. This was Compagnie de Bauxite de Guinea versus the Insurance Company of North America, a 1983 decision of the Third Circuit Court of Appeal. Courts have further concluded that a fortuity inquiry should look to, among other things, whether a particular loss was certain to occur, the party's perception of risk at the time the policy issued, and whether some courts have adopted a subjective test of fortuity. If the insured was not aware of the defect or a vice inherent in the insured property, the damage resulting from that defect was unanticipated or unforeseen. The loss is fortuitous from the standpoint of the insured and is within coverage. One court stated, "We think it inappropriate to cause the insured to suffer a forfeiture by concluding with the aid of hindsight that no fortuitous loss occurred, when, at the time the insurance took effect, only a risk was involved as far as the parties were aware." This is De Guinea versus Insurance Company, a 1983 decision, and Miller's Mutual versus Morrell, a 1962 decision. In determining the damage to the insured's dwelling was fortuitous, the court in Miller's Mutual stated, quote, "It is true that all the expert witnesses who, after the damage, examined the underlying structures of the earth, noted the capacity of the soil to absorb water, and saw evidence of earth movement, said that damage similar to that which occurred was inevitable. But we are not told who, at the time the insurance contract was executed, had certain knowledge that the damage was inevitable." In the Compagnie de Bauxite's case, an insured brought suit against its all-risk insurer to recover business interruption losses arising from the structural failure, collapse, and deformation of a tippler building and crusher house used in the mining of bauxite ore. The trial court found no coverage because the damage resulted from the defective design of the building and was not fortuitous. The Court of Appeal, predicting what a Pennsylvania Supreme Court would adopt the restatement of contracts, and that insurers could not avoid liability for what appeared to be an inevitable loss by relying upon the fortuity requirement at all. It seemed that wear and tear should not be limited to ordinary wear and tear, but also extraordinary wear. As one court indicated, an excessive degree of abrasion does not necessarily preclude a finding of wear and tear. This video was adapted from my book, Zelma on Insurance Claims, Volume 4, 3rd edition, which is available now as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications, so that you can be advised of future videos and future blog postings. Thank you for your attention.